Good evening. This is Joseph Blake from Watchdog Fire Protection Services. You know, I've been experiencing some really, outrageous responses from the circuit court, the entire circuit court in Kanawha County, West Virginia. And I'm going to start my podcast off tonight with I'm going to start reading a monologue. It starts off, they call my cases frivolous. Frivolous. When I stand here fighting to protect a child from abuse and neglect. Frivolous. When I demand a jury trial, the very right guaranteed to me under the Constitution. Frivolous. When I present evidence, recordings, and sworn testimony that the judges refuse to hear. But what is truly frivolous is it my pursuit of justice, or is it a court that plays musical chairs with judges, never once reaching the merits? Is it my filings, or is it the 8 judges acting as a group to run from their duty, only to be forced back by the Supreme Court? It is my persistence, or is it my system where CPS ignores court orders and guardian ad litem twists the voice of a child into silence? The United States Supreme Court has made clear that the right to be heard is fundamental due process right. Goldberg versus Kelly, 397 U.S. 254-267, 1970. For instance, is it frivolous to respond to Judge Slangel's, Judge Stephanie Abraham, and Judge Jennifer Bailey when they preside over the removal of your child from your life based not on truth, but on lies and deception? Is it frivolous when the only thing you are truly guilty of is calling the police to report child abuse? Is it frivolous when, after making the call, CPS and the courts twist everything and do complete reversal, accusing you of the very crimes you tried to stop? And is it frivolous then when you fight back, when you refuse to accept those falsehoods, when you put your defense in writing, only to have your filings dismissed, branded as frivolous? The Supreme Court has warned against this very thing. The loss of parental rights is far more precious than property rights, and due process must be applied with scrupulous fairness. Santuski versus Kramer, 455 U.S. 745, 753, 1982. And if defending your child is frivolous, then what does this court stand for? If exposing lies is frivolous, then what is the truth worth here? And if calling the police to protect your child makes me the criminal, then the system is not protecting children, it is protecting itself. Is it frivolous when I respond to false allegations made by corrupt CPS workers who claim I stalked and harassed her without once sharing any evidence whatsoever? Judge Kerry Webster couldn't care less. I now have a lawsuit pending against that individual. Tell me, how is that frivolous? Is it frivolous when I walk into Lima's Place, a business that exists only to monitor parents during supervised visitation, only for them to invent accusations of inappropriate behavior? They carried that lie straight to the court through an ex parte communication, an illegal act, and Judge Tara Slango not only accepted it, she used it as an excuse to strip me of any chance of unsupervised visitation. The U.S. Supreme Court has said plainly that ex parte communications they avoid due process. They're illegal. Is it frivolous for me to sue Liam's Place for defamation, for negligence, for damage they caused? Judge Kenneth Ballard dismissed the lawsuits the first time, handling Liam's Place, giving them absolute immunity, as if they were above the law. Is it frivolous for me to refile, as the law allows, and bring the case before Judge Hardy, only for Judge Ballard to drag it back in his own courtroom? Is it frivolous when Judge Ballard then makes the defendant's argument for them, throws out my claims, and labels every single one of my cases as frivolous, simply because the defendants are his friends? Is it frivolous when judges dismiss my cases through the mail system without hearing, without any testimony, without any evidence ever being allowed? One case at a time, stripped away in silence. Even the West Virginia Supreme Court has held that litigants are entitled to meaningful hearings. A hearing in name only without without affording an opportunity to present evidence does not comport with due process. It just doesn't. Is it frivolous when they ignore my request for a jury trial? Not once, but in every single case I have filed. The Constitution guarantees the right to a jury trial. Article 3, Section 13 of the West Virginia Constitution says clearly, in suits at common law where the value is controversy shall exceed $20, the right of a jury by a trial by jury is required by either party shall be preserved. Yet in Kanawha County, it has been stolen from me at every turn. Is it frivolous for me to refile those cases as the law permits and ask for the change of venue so that my claims can be heard in the court untainted by bias? And is it frivolous when those monitors or the motions are ignored, buried under the weight of a system that would rather protect itself than protect the rights of the citizens? Is it frivolous when Judge Kenneth Ballard, in open court, looked me in the eye and told me, I don't have any rights? That's on the transcript. You don't have any rights. This is the Chief Justice in Kanawha County, by the way. Am I being frivolous when I respond to that? Am I frivolous for insisting that Constitution applies to me too? Am I frivolous for refusing to accept courtrooms where the judge himself declares that due process does not exist? Is it frivolous when I respond to Judge Ballard ignoring my pleas for help in protecting my family, pleas that sat unanswered for more than 7 months? Is it frivolous when I respond to Judge Tara Salango and Judge Stephanie Abraham, who left my emergency child abuse and neglect petitions unheard for over a year? We're into our 3rd year as we speak. And is it frivolous when, after being stonewalled at every turn, I file a writ of Miranda's, a lawful request for the court to do its duty, only to have Judge Jennifer Bailey's only action on my emergency case be to dismiss it outright without ever hearing a single word? That's right, ladies and gentlemen. She waited for me to file a writ of Miranda's after 8 months in her court. In years before that, before Salango and Abraham, never being heard. And then the first action she actually takes is to dismiss my case without ever hearing it. It's ridiculous. Is it frivolous when I have the testimony of a decorated detective, an officer of the law, completely ignored because the words would have returned my granddaughter to us safely? Is it frivolous when I bring forward his sworn testimony backed by evidence and the court turns away, not because it was weak, but because it was too strong? Is it frivolous when I appeal to Alex Mayer, the new head of CPS in West Virginia, with clear proof of lies and deception by workers under his command, only for him not only to ignore the evidence, but to reward the dishonesty? Is it frivolous when Alex Mayer himself removes CPS worker Nathan Phillips from the case, the very worker who was recommending unification with the father, and literally replaces him with someone under his direction whose only mission was to push for termination of parental rights? And is it frivolous when that manipulation, the manipulation of those rights are in fact terminated? Not because of truth, not because of justice, but because CPS decided that a child's bond with her family was an obstacle to be destroyed. Is it frivolous to respond when all 8 circuit court judges in Kanawha County tried as a group, not individually, as a group, to recuse themselves from every one of my cases? Is it frivolous to point out that these judges had already been avoiding my cases for months and years because the testimony inside them, if ever allowed to be heard, would exonerate my son and return our child to safety? Is it frivolous when those judges, instead of facing the evidence, instead of honoring their oath, attempted as one body to block me from ever being heard again? Thank God the Supreme Court saw through their organized attempt that tried to deny their request. But is it frivolous for me to respond to a coordinated act of obstruction designed not to protect justice but to protect themselves? Is it frivolous when Judge Bridger Lindsay has allowed for months a motion for default of judgment against his friends to sit ignored, never ruled on, never addressed, as though it did not exist? Is it frivolous for me to file a writ of Miranda's to compel him to act when the law is clear that courts must rule on motions before them? Is it frivolous that on all 3 writs I have filed, the judges chose not to address the merits, but instead complained about the very way I served them? And I served them by certified mail with green card return receipts. More than sufficient. And the truth is, under the rules, I could have legally served them by regular U.S. mail. Is it frivolous for me to contest that this ridiculous complaint, to stand and say that my filings were proper, and that the fixation on service is nothing more than a smoke screen to avoid the substance of my claims? No. What is frivolous is burying the detective's testimony because it points to the truth. What is frivolous is reshuffling CPS workers until the right outcome is guaranteed. What is frivolous is the 8 judges conspiring to silence a citizen rather than hear the truth. What is frivolous is twisting service rules to dodge accountability. What is frivolous is taking the voice of justice and silencing it with lies, deception, and deliberate manipulation. No. What is frivolous is a judge mocking the very foundation of justice. What is frivolous is stripping a citizen of his rights in plain view of the record. What is frivolous is using the bench not to uphold the law, but to silence the people the law was meant to protect. So call me when you will, or so call me what you will. Call my cases frivolous, call my filings frivolous, call my persistence frivolous, because if standing up for my granddaughter, if demanding the truth be heard, if refusing to bow to corruption is frivolous, then I will proudly wear that word as a badge of honor. As a badge of honor. Frivolous is not my shame. Frivolous is their defense. And the day will come when the record shows it will not by my pursuit of justice that will be frivolous, but the court's refusal to deliver it. You know, it's absolutely outrageous what these courts are doing right now. I mean, they're literally ignoring our pleas for justice. I'm going to show you a document here, which is very interesting. I'll show it to you. This is of the 8 judges, the entire circuit court, filing a motion to the Supreme Court to try and have my case, or all my cases, not be heard in their courts. Now, obviously, if they were successful, that would mean that I would have nowhere to go to discuss my cases, to fight them out. It's reprehensible. I mean, obviously, thank God that the Supreme Court saw through it and realized that these judges they're acting out of hatred, they're acting out of vengeance, and I don't even know why they're being vengeful. The only thing I'm doing wrong from their standpoint is fighting them. Now, if fighting the system is corrupt, then, I mean, that's ridiculous. The only reason we're fighting the system is because they are corrupt. I mean, the entire circuit court tried to do this. And I mean, at the end of the day, if they were successful, that means that I would not have any judge to go to, because you're under legal obligation to go to a circuit court in your community. They didn't even find another judge in another district to take my case. They just said, you know what, we want to hear what Mr. Millay has to say, because you know why? Because if he wins any of his cases, it's going to make us look bad on the cases we've already ruled on with his son. Because he has the same testimony, he has the same witnesses, the exact same experience. I don't need my son to tell me what's going on. I experienced this myself. And they don't want that to be revealed, because they literally went out of their way completely on my son's case to suppress all the evidence. Judge Bailey literally dismissed every single witness my son had, including the detective, the other CPS worker, Nathan Phillips, who was going to come in and recommend unification. That judge wanted nothing to do. Judge Bailey wanted nothing to do with the truth, and that's why she dismissed all the witnesses. But she knows that she's not going to be able to do that with me. If she ran my case simultaneously with my son's, okay, rather than waiting till my son's case was terminated, and then she decided to cancel my case after 7 months of standing stagnant in her court, it's outrageous. It's obvious it's pre-planned. You know, so we're trying to figure out different ways to get these judges to start doing the right thing. Hopefully I filed a writ of mandamus, or actually a writ to remove these judges from any of my cases, because I don't want them on my cases. I want them on my cases like they wanted to be on my cases, which is not at all. In fact, when I first opened up all my cases, the first thing I did is I filed a motion to recuse each judge, because I knew they were literally friends with the defendants. In some cases went to school, but they've known them for years as prosecutors and whatever. So how can you possibly depend on a judge to be fair when the defendant is a personal friend of theirs? But when they decided to do this thing with their motion to the Supreme Court, that was really the icing on the cake for me. And it should be for you too, because for all you people that when you watch this program over again and you pause that and see what judges are involved, if you have any of these judges in your case, you have reason to believe you're not going to have a fair trial. Because this is not their first rodeo. They're good. I mean, they're not real good because they're getting caught, but I mean, they're good in the sense that they're such a tight-knit group that they're willing to hang it all out there to protect one another. They really believed that the Supreme Court would have allowed them to follow through on this ridiculous mass recusal, but they were wrong. So that being said, this is going to be a short tonight. I like these shorts. Seem to get better response on them. So I'm going to do that. And like I've always said, I am not anti-family court. I am not anti-CPS. I am pro-justice. Thank you.